Crazy news out of the state of New Jersey when it comes to qualifying to carry guns outside the home in public, which is a constitutional right, as per the text of the Second Amendment and the Supreme Court precedent of NYSPRA versus Bruen. We're going to talk about this major article just written by a fantastic gun writer, Lee Williams, when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms. Check that out on Amazon. It's available on audiobook as well as Kindle. All right, folks, so a great article this morning. I picked up this article from Lee Williams from The Gun Writer. That's the name of his Substack, The Gun Writer. And Lee Williams is associated with the Second Amendment Foundation's Investigative Journalism Project. He's also a well-known writer in the Second Amendment space. I receive his emails just about every week, I think, and I always try to get through his emails. I don't always get through all of his articles, but I try. But one caught my eye today, dealing with New Jersey. A great title for this article by Lee Williams. He says, this is the title of the article, Deep Dive, New Jersey's New John Wick Concealed Carry Qualification Test. Specifically, he says that anti-gun elected officials in New Jersey, of course, have found a new way to infringe upon the Second Amendment. So I took a look at this article by Lee Williams, and indeed, it's crazy what he was able to uncover in the state of New Jersey. You see, as you know, New Jersey is one of those terrible states when it comes to our gun rights. Specifically, before NYSPRA versus Bruen, a couple years earlier, there was a case called Rogers, which presented the exact same legal question as Bruen about whether or not May issue permitting regimes were constitutional. Of course, Rogers was denied cert by a Supreme Court that included Ruth Bader Ginsburg on the court, and Bruen was decided in our favor when Ruth Bader Ginsburg passed away and was replaced by Justice Amy Coney Barrett. So a different Supreme Court. Again, we won't get into that historical discussion right now. I want to focus on this crazy New Jersey thing. So according to Lee Williams, he says that, of course, obtaining New Jersey carry permits has never been easy, which is true. By the way, it was extremely easy. It was extremely easy until like the 1960s. The history of New Jersey carry was actually very favorable. In fact, I don't even think open carry was outlawed in New Jersey until just a few decades ago. But now they've gone full-blown anti-gun nut job. But that was not always the case for most of American life and most of the life of New Jersey as a state. It was not insane, but now, of course, they're insane. I'll let you speculate as to why that happened. Nevertheless, Lee Williams goes on to say that getting a gun permit in New Jersey is not easy now. It remains an expensive, multi-step nightmare specifically designed to make the process as difficult as possible for the applicant. No shock there. That's what they're trying to do. I'm sure there'll be lawsuits, if not already, on some of these issues as well. There should be. Now, what got my attention, of course, is that the superintendent of the New Jersey State Police, in conjunction with the state's anti-gun attorney general, issued new requirements titled Use of Force Interim Training for Private Citizen Concealed Carry. Of course, private citizens and cops are the same because we all walk the same streets and we all confront the same criminals and we all confront the same evil. Police are not military. Police are civilians, as a side note. Okay, they may get paid by the government, but at the end of the day, police officers and American civilians, they're all one and the same. We're all civilians. Okay, with that said, basically, according to Lee Williams here, if you look at the requirements to conceal carry, there is now a testing requirement. Now, this is key. Training and testing are not the same thing. If you look at NYSPRA versus Bruen, Brett Kavanaugh talks about how, for the purposes of the moment at least, shall issue carry regimes, provided they are objective, are likely constitutional. It wasn't fully decided. It was dicta. But nevertheless, Brett Kavanaugh wrote with John Roberts in concurrence with that, or signed on to it, said that 43 states currently employ objective shall issue licensing regimes. Those shall-issue regimes may require a licensed applicant to undergo fingerprinting, a background check, a mental health records check, and training in firearms, handling, and laws regarding the use of force. What is not in that language? Testing. You see, training and testing are not the same. The purpose of this testing, and wait till I go through the details of this testing process, is insane. The purpose, of course, is they want to weed people out from being able to protect themselves and exercise their right to keep and bear arms. That's what they're trying to do here with the testing requirements. Now, what are these testing requirements that Lee Williams wrote about in the Gun Writer Substack post that he did? Specifically, every concealed carry applicant is now required to pass a 50-round qualification course. 50 rounds. Okay? We know there's no other Second Amendment, there's no other constitutional requirements to engage in testing. We don't test people, are they good writers before they get a job as a journalist or before they're allowed to post a Twitter tweet or write on their Facebook page or write a letter to the an op-ed to the letter, or letter to the editor, or an op-ed to the local paper. There's no test associated with any of this. There's no test before you exercise your right to vote. There's no test before you can show up and exercise your right to petition the government for a grievance you may have or to show up at a protest. There's no testing going on before you exercise any of these rights, nor do you have to engage and pass a test to pray to God, to go to Mass, to go to church. Obviously, all this is absurd and unconstitutional. But here you have New Jersey says you have to pass a test to earn, right? Lee Williams says this, powerful language. You have to pass a test to earn your Second Amendment rights. This is clearly not permitted, and there's no historical basis for this at the time of the founding to test people before they can carry guns peaceably for self-defense or for any lawful purposes. Now, under the New Jersey rules here, it says applicants must fire with an 80% accuracy rate. 80% accuracy rate at an FBI-type Q target, which correlates to the size of an oversized milk bottle. By the way, I'm going to link to the Lee Williams article down below. Now, this is crazy, right? The other thing that's shocking to me is, as a former athlete, I'm pretty much familiar with 25 yards because I know how hard it was to move a football 25 yards down the field. So here you have applicants have to fire from 25 yards away, 75 feet, 25 yards away. Okay? Now, Mr. Williams makes the point in his article that this prevents people from being able to use 9mm or 380s, right? Because 25 yards away is crazy long. And by the way, I'm trying to understand under what circumstances would I be allowed to exercise deadly force from 25 yards away? I gotta say, that's pretty far away. I'm not sure I'd be shooting anyone at 25 yards. I'm not saying I wouldn't shoot maybe a charging animal. Maybe there are exceptions to that. I suppose if someone had a gun and was running toward me, going to shoot me from 25 yards away, I might open fire. But 25 yards away is a pretty long distance as to whether or not that's even legally allowed under, deadly force rules. Nevertheless, that's part of this test for the state of New Jersey. It's not training. They're not teaching you how to do it. They're testing you to make sure you can do it in proficiency, which we don't do for any other constitutional rights. And again, this is all part of trying to weed out Americans from being able to exercise the Second Amendment right to keep and bear arms. The other interesting thing that Mr. Williams talks about in his article is the course is designed for open carry. Now, you're not allowed to open carry as an American citizen in New Jersey. You have to be working for the government as part of you got to be a police officer or working for the government in some way, but ordinary Americans have to conceal carry in New Jersey. Nevertheless, they test you for open carry in an open carry holster. What's up with that? That doesn't even make sense. The other thing is, but believe it or not, according to Mr. Williams' article here, in his review of the New Jersey regulations, they also test you have to fire 3 rounds offhand. So if you're right-handed, you have to fire 3 rounds with your left hand. Like, why do you have to be a Navy SEAL to carry guns? Obviously, this is absurd, right? Constitutional rights does not require you to be a crack shot, a sharpshooter, to be quickly down under. This is a constitutional right. You don't have to be a good writer to exercise your First Amendment. Rights to free speech. You don't have to be a good speaker to talk to the local PTA board. That's not how it works. The reality, of course, is a lot of this test appears to be illegal and impractical, likely unconstitutional. Again, They're going to try to rely on some of the language from Bruen, but Bruen just said that shall issue permitting regimes are okay if it's objective. But this testing requirement goes beyond anything that NYSPRA versus Bruen talked about or any of these other states talk about. Because again, this is not about firearms training to make sure that you don't shoot yourself, you know how to use the safety. This is literally making sure that you are a crack shot. And while it's a great idea that you're a crack shot, the reality is most self-defense events are going to be within a few feet. Someone's coming upon you and you need to shoot them either in the home or on the street. By the way, I should also mention the other thing that New Jersey requires is you have to shoot from your knee. Okay, what is all this about? I mean, again, if you're in the military and you're going to be, in Mogadishu or something, yeah, I get it. But just to protect yourself from local, scum that want to kill you, or attacking animals, like attacking, marauding dogs or something, or bear, whatever it is, whatever may threaten your life, I don't think you need all these techniques. It's maybe great to have, but to be able to do all this stuff in order to exercise your right is clearly unconstitutional under the Second Amendment is my best guess. And I suspect that lawsuits will be brought about this if they haven't already. And I will, of course, keep you abreast as to the events there in the state of New Jersey, which is part of the Third Circuit. And remember, the Third Circuit Court of Appeals is not a bad federal jurisdiction for Second Amendment-related lawsuits because it's the Third Circuit Court of Appeals that gave us the Bruen Range decision, meaning in Range versus Garland, that says that nonviolent felons have a right to keep and bear arms, and that 18 U.S.C. 922G's prohibited people don't apply to people like Bruen Range, i.e. people that have been convicted decades ago of nonviolent misdemeanors, in that case in the state of Pennsylvania. So, all right, folks, again, I'll keep you up to speed. Great job in this article by Lee Williams. Unfortunately, he's bringing us bad news, but still he does it in an articulate, interesting, and fun, entertaining way. So if you haven't subscribed to the Lee Williams, the Gun Writer Substack, you may want to check him out. I'll put links to this article down below. I know I get his emails every week and I enjoy reading them. Okay, folks, hope you have learned something here today. If you haven't subscribed to the Four Boxes Diner, please do so, and feel free to like this video. We're working hard to try to increase our number of subscribers. We seem to be very far behind everyone else in the Second Amendment community for some reason. Maybe they don't like the color of my shirts. I don't know. Nevertheless, I'd appreciate your support, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.